Someone's sons inspire them. Beautiful. People's partners inspire them. Love that. Gratitude for the people who inspire us today. Oh, so good to see so many community members here in attendance. We are so grateful for you all taking the time to see us. Love that. Well, we're going to go ahead and get started just because we have just a short 1 hour time together. My name is Smelia. I work at the Ella Baker Center. I'm a program coordinator on our team, and I use she, her pronouns. We're so excited to welcome you to learn about the RJA. This law is so fundamental and it is going to be so game-changing for so many people and our loved ones and community members inside and people in the future. We have some brilliant team members here to talk to us about it today. And people can feel free to continue to introduce themselves in the chat, but we're going to get started. And I'm just going to pass it to Morgan first to introduce herself, and then Derek will get started with the content of today's presentation.
Hi, everyone. Morgan Zamora, pronoun she, her. I'm the prison advocacy coordinator at the Ella Baker Center for Human Rights.
Hey, good afternoon, everyone. I apologize if you can hear a little bit of the sounds of Oakland in the background. I've got some really cool neighbors. But my name is Derek. I use he, him pronouns. I'm a policy associate here at the Ella Baker Center for Human Rights. And I'll pass it to our intern, Angie.
Hello, intern here. My name is Angie. I take they, she pronouns. Really excited to be helping to facilitate today's webinar and to talk to all of you guys here today. Thank you for joining us.
Awesome. Thank you. So I'm going to start just screen share and Derek will kick us off.
Thank you, Smelia. So thanks again for taking time out to share with us about the Racial Justice Act. It's a groundbreaking law, and it's the first law of its kind in California that affirms civil rights in the courtroom. Today, we'll cover a little bit of background on the law, what's in the law, what are the violations that you can use to bring a claim in the RJA in the courts, some recent examples of how the RJA is already working, some tips on how you can support your loved one with their RJA claim, and then if you'll allow us, we'll take some questions from you. So first, let's start with the background on why California passed the RJA. California, well before the RJA started in California, the RJA was inspired by the McCleskey court ruling, Supreme Court ruling. It overturns that ruling that for the longest time treated discrimination as something that was harmless or inevitable in our criminal legal system. In that case, a defendant from Georgia went to the Supreme Court to challenge how Georgia applied the death penalty. And in that case, his defense brought a study of over 2,000 cases in Georgia that showed that Black men were significantly more likely to be sentenced to death than any other group, especially white men. Still, the court refused to do anything about it because they treated racism as something that was inevitable in our system, a harmless error. But racism is never harmless. That precedent made it so that no matter how much evidence of racism you could show to the courts, the system would do nothing about it. And here in California, our courts aren't much better. Black men are 9 times more likely to be incarcerated than white men. This disproportionate treatment of Black men in California is worse than it is in Texas, worse than it is in Florida, worse than it is in Mississippi, worse than any other state in the South. And then, of course, there was 2020. When we saw the many tragedies we saw that year, but how many of them were based on race, who was left exposed to die to a horrible pandemic. And the killings that we saw of George Floyd and Breonna Taylor, who was left to die the pandemic of racism in our legal system. That urged not only California, but us all throughout the country to demand a change to how racism infects our criminal legal system. And with that, California gained the Racial Justice Act. The RJA creates a right to challenge discrimination based on race, ethnicity, national origin in any of the state's criminal proceedings. The law creates Penal Code 745 to enshrine these civil rights. And it allows you to bring 4 types of behavior that violate the law: explicitly racist behavior, explicit bias, racist statements, and 2 disparities claims, sentencing disparities and charging disparities. The law provides remedies to address the violation, and thanks to AB 256, it will soon apply to everyone, so anyone can raise these claims no matter when they went to court. So let's talk about the first violation, explicit bias. This first category looks at explicit bias that's aimed at the defendant. And it can be from any of the key actors in a commission, from a police officer, an expert witness, a juror, a prosecutor, even a defense attorney, and even the presiding judge. Explicit bias is an outward expression of hate or targeting with ill will because of someone's race. And a recent court ruling from Solano County affirmed that the RJA also recognizes racial profiling as an insidious piece of discrimination that can be raised with a claim. In Young versus Superior Court, that's the Solano case I'm mentioning right now, the defendant there brought an RJA claim to challenge the Solano County Police Department and the racially motivated way that they arrested him. In that case, he was pulled from his car, beaten, and arrested and charged just for watching the police arrest someone else, another driver in another vehicle. To support his claim, he showed that race was definitely a factor because the police had time to note his race. They approached him from the front and were aware of him. They recognized his race, and not like being pulled over by a car behind you. In this case, race clearly could play a factor. And he supported that claim with racial disparities in Solano County. The RJA is a tool to confront racism in the courts at every step in the legal proceedings. Next, let's talk about racist statements, the second type of violation. This type of violation covers racist statements and also implicit bias at trial. This category looks at how this type of bias can be often unconscious and still show up in the courtroom. Racially charged language includes slang, racially coded language, and even comparing the defendant to an animal. All that was previously seen harmless, but not under the RJA. One of the poisons of racially charged language is that it not only reveals our own biases to other and alienate and lessen each other, but it also triggers those same biases in everyone that hears them. An example of an RJA claim used to challenge this comes from Contra Costa County. In People versus Bryant, the defendant there challenged the prosecutor's repeated use of the N-word, slang terms, and even his twisting of their rap music as criminal evidence. After an RJA hearing on the matter, the judge found that the prosecution's repeated use of this type of language was an implicit trigger meant to trigger that bias in the jury. And with the claim, or with the entire case now tainted, the judge ordered a new trial. Even if it's unconscious, racism is never harmless, especially when it happens in our courts. Next, let's look at our disparities claims. So the next two claims are going to look at your case compared to other cases in the counties for systemic issues. The first is overcharging. This looks at the charging decisions of prosecutors. A violation here shows that you were charged more harshly than others essentially doing the same thing, and that county more often seeks higher charges on people who share your race. This type of claim doesn't just consider statistical evidence and data. It can also take into account someone's criminal history and how that was tainted by racial profiling and racial targeting. So for an example here, let's look at the Young case that I mentioned earlier. Since prosecutors rely on police to bring them cases to prosecute, a racial targeting by the police has a downstream effect on who ultimately gets charged in that county. So in the Young case mentioned earlier, the RJA claim is not just challenging the racially motivated police stop, but also the charges that was filed against him. Whether purposeful or not, race-based disparities and charging outcomes are the type of systemic issue that the RJA speaks directly to. And now let's look at the last violation, disparities in sentencing, over-sentencing. This last category or type of violation is shown when a judge hands down a more severe sentence on you than others who are convicted of the same crime. And the county more often seeks higher sentences for people who share your race. Like the prior disparity claim, this RJA violation compares your case to others in the county and looks at statistics, but it also takes into account the race of the victim of the crime. For example, in the McCleskey case that we mentioned at the top, that study that showed that Georgia more often handed down the death penalty on Black men also showed that the race of the victim played a factor. For example, when a Black man was charged in a crime with a white victim, he was twice as likely as a white man who had a white victim to be sentenced to death. With the RJA, this kind of race-based disparity is no longer treated as inevitable. Now let's review the violations that are covered under the RJA. There are 4 types of violations, and the first 2 look at the actions from any of the principal actors in the trial or in the conviction: a police officer, juror, any of the attorneys, and even the judge. The first is explicit bias towards the defendant. The second covers racist statements and implicit bias in the trial. And then the last 2 are the disparities claims, overcharging and over-sentencing. The violations do not need to be purposeful to be proven. Some violations, some biases are unconscious. The point here with the RJA is to see these biases with open eyes so that we can address them. Now let's talk about how the law requires that we address them. Under the RJA, when a violation is proven, the court has to apply a remedy specific to the type of violation that happened. And often the defense can ask for the appropriate remedy. An example here is that the court can remove a juror or bring in a whole new jury if they need to at trial, reduce charges, dismiss sentences, dismiss dismiss sentence enhancements. And if a violation is proven, you are no longer eligible for the death penalty, because we know how racially tainted the death penalty is. The court can also order a whole new trial, a do-over without the racism. With these remedies, we need to keep in mind that if you were convicted before 2021 and your claim is based solely on the first two types of violations, the explicit bias or racist statements, the prosecution gets a chance to block relief if it can prove beyond a reasonable doubt that the violation had no impact on the verdict. This only applies to past cases, and only to those past cases that are bringing solely a claim under those first two categories. This is an ugly amendment to the law that came in the campaign to extend the RJA to folks who had seen racism in the system before the RJA was law. Despite that, the spirit of the RJA still rings true. We must confront racism in our system of justice in order to heal it, and our healing will leave nobody behind. So when will it apply? Retroactivity. Currently, the law applies to all new trials and anyone facing a juvenile transfer hearing or prior death penalty convictions, or folks in criminal trials, state criminal trials facing immigration consequences. Starting in 2024, that's the biggest year, let me not skip that. It's going to apply to everyone who's currently incarcerated for a felony, whether they're in prison or jail. In 2025, it'll apply to folks who are no longer incarcerated, going back 10 years. And in 2026, it'll apply to anyone convicted of a felony or committed to DJJ ever. So that's a little overview of the RJA, the law. And now I'll pass it to Morgan with some examples of how it's already working in action.
Thank you, Derek. So one of the prime examples of explicit bias and the type of language that can be used to bring an A1 claim under the RJA is the evidence and the investigation that's coming out of the Antioch Police Department texting scandal. I'm sure all of you have heard about this already or seen it on the news, very prevalent over the last few months, especially since the reports were publicly released. But these messages suggest that the police, at least in the Antioch department, are complicit in potential abuses of authority, civil rights violations, perjury, and other violations of the Racial Justice Act. You can see the linked reports for examples of the type of language being used. Most of it is far too inappropriate and harmful to be repeated, but to give kind of an overview of what is contained in those reports so that you're all aware, there is a lot of derogatory and stereotyping language about racial minority populations, but specifically focused on Black populations. There's constant usage of the N-word and other stereotyping language, including references to Black men as gorillas and monkeys. There's also direct phrasing from an Officer Ramba in relation to specific individuals saying that he's only stopping them because they're Black. The reports also contain statistics for at least 2 officers that show racial disparity in their giving citations, as well as canine deployment and dog bites. And there are also threats against elected officials like Antioch Mayor Lamar Thorpe, who's Black, as well as Antioch Police Department Chief Ford, who is also Black. Just to understand the scope of this scandal, Antioch has 99 presently sworn officers, 45 of which are named in the report, meaning that nearly half of the force has been put on leave since these findings came out, 16 of which hold or held management positions. As of April 23rd, the Contra Costa County District Attorney dropped over 40 cases tainted by the involved officers, We know of at least one claim filed by defense attorneys for 4 men, 2 of which were specifically named in these text message exchanges. And these attorneys are arguing that officers unfairly targeted the defendants based on their race. For other claims, these texts may serve as a basis for future A1 explicit bias claims in any cases that aren't thrown out, or current claims for those who are already incarcerated or undergoing legal proceedings that involve these stated officers, particularly the 17 that sent the messages in the text exchanges. And the most recent update here is that Antioch Police Chief Ford announced his retirement and resignation effective August 11th. And it's important to mention that he wasn't specifically involved in the scandal and that there were only texts naming him and making racist references to him by other officers. And another really exciting decision that came down in May, a landmark ruling, the first of its kind regarding charging disparities in A3 claims under the Racial Justice Act, where a Contra Costa judge granted a motion to dismiss gang enhancements against 4 Black individuals on the grounds that the Contra Costa County District Attorney's overall charging practices disproportionately apply special circumstances to Black defendants in gang-related murders in violation of the Racial Justice Act. I think it's important to mention that this ruling is entirely unrelated to the Antioch texting scandal and doesn't pinpoint any specific attorney within the DA's office. It's more of a general ruling on the overall organizational structure of the county office. You can see the link for the full court order. The findings in this court order have a lot to do with the type of information that's needed to prove a Racial Justice Act violation, specifically for A3 claims. A charging disparity has to be significant to establish an RJA violation, which relies on a lot of statistical data. Here, a sample pool of about 90 defendants over a decade was found to be significant for RJA means, and the analysis of that data showed that Black defendants are 44% more likely to be charged with special enhancements compared to others within Contra Costa County. In this specific case, prosecution failed to call its own expert, present its own statistical analysis, and present evidence or an argument for a race-neutral reason for these charging disparities that were found. Their general argument was that the disparities could be explained by other factual means, and the judge here found that to be insufficient because it lacked specificity. It didn't give a real articulate reason why this charging wasn't race-based. And it's important to note that in the future, especially regarding A3 claims, prosecution may be better prepared to defend against these types of claims now that they know they have to make a better showing to prove that there was actually a lack of racial bias in charging. Overall, this is a really positive ruling. It makes reference to the fact that the RJA is meant to expand protections and ensure that more people can make claims than under the 14th Amendment or other anti-discrimination laws. The ruling reiterates what we already know is codified in the law. The Racial Justice Act doesn't require proving prejudice or otherwise showing that there was an unfair trial. The discrimination itself, the basic understanding of it and like what it actually is enough to create an error in the proceedings that needs to be addressed and needs to actually be remedied. So I'll pass it back to Derek to talk more about how to bring a claim under the Racial Justice Act.
Thank you, Morgan. So very, very basically, an RJA claim has 3 parts. First, you alert a judge that a violation happened. Then, if the judge approves, they order a hearing where that violation can be proven. And if that hearing shows that more likely than not, a violation happened, the judge will order a remedy. The process looks different depending if you're currently at trial or if you're bringing a claim after conviction. If you're at trial, the RJA claim starts with a motion in court that your attorney will bring. But when you are incarcerated, your RJA claim actually starts with a habeas petition to bring you back to court. So let's look at a little bit of that habeas process. To start, you'll want to use form HC001. That's the California court form that specifically applies to challenging a conviction. You'll fill in the background information, and then under question 6, your grounds for relief, you'll describe the violation of the RJA, the Racial Justice Act, or Penal Code 745, if you want to get nerdy about it. And no shame, I'm clearly nerdy too. Be as specific as you can when you're describing the actual violation. Describe the actions or statements that violated the RJA, who the person that did these violations, or even the agency involved. State on the habeas form that you request an attorney. That way, if it's approved, one will be appointed to you free of charge. And you can also include supporting documents. These include news stories exposing the bias from any of the key actors in your conviction, reports of disparities in your county, and evidence of racial profiling affecting your case. Make a copy of your entire packet, your habeas packet, if you include any special documents too. You'll need to submit the original and a copy to the clerk of court in the county of conviction. And the court will review that packet, and within 45 days, they will appoint an attorney for a hearing or deny the claim. And there's some special tips actually if you're bringing a habeas claim for a capital case, a death penalty case. And for that, I'll pass it to Morgan.
Yeah, so if your loved one has a capital sentence, there are some risks with filing an RJA petition due to special rules imposed by Prop 66. Prop 66 changes procedures governing challenges to death sentences by limiting the number of petitions that can be filed. So sentenced persons only really get one bite at the apple. They only get one opportunity to file their habeas claims. So filing an RJA petition will likely prevent your loved one from raising any other habeas claims that they have not already raised. If your loved one's under a sentence of death and thinking about filing a pro-per RJA petition, or if they have questions about the RJA, it's best to reach out to their contact at the California Appellate Project or their currently appointed attorney prior to filing, just to make sure that they're fully aware of the potential impact that an RJA claim could have on their case. Ultimately, it is their decision, but we just want to make sure that everyone is fully aware of the risks and how that could impact their case. And I will throw it back to Derek to talk more about how you can help support your loved ones.
Thank you, Morgan. So how can you support your loved one? First, I want to shout out Silicon Valley Debug. They are just a incredibly powerful and passionate organization, and really a model of how to empower families to support each other against the weight of the legal system. So if your loved one is currently at trial, one of the best things you can do is court watch. Be another set of eyes and ears for the defense. Remember that biases can be subtle and unconscious, but you should look out for words and actions, statements about your loved one or towards them that don't sit right. And if you spot a violation, alert your loved one's attorney, but alert them in private. And do that as soon as you can. If they are incarcerated, one of the best things you can do is help them gather supporting documents. Read the trial transcripts for unnecessary slang or racially coded language when anyone talks about your loved one or the crime that they were charged with. Get the abstract of judgment and criminal records, and actually any information you can get on their criminal conviction, whether they have enhancements, all the charges that make up their conviction. Those will be very, very important later. And also gather news stories and reports that reveal racial bias or the targeting of your community by any individual involved in the case or any agency. We cover some of this in our guide. We do for sure cover the violations and a couple of the court cases that have helped color the law. And for more info on that, I'll pass it to Angie.
Hello. Oh, I don't know if my video is working, but that's okay. Hope everyone can hear me. But there is a lot more about the RJA that our guide covers, actually. We are limited in time for this webinar, but if you are curious about what other kinds of areas the RJA can cover and what kinds of help that you and your loved one can find with the RJA, we have a guide available in both Spanish and English at ellabakercenter.org/RJA-info/. And oh, awesome. I can start my video now. That's awesome. I can also drop this link in the chat. If you have any specific questions about your particular circumstance, your particular loved one, you can also email us at policy@ellabakercenter.org. We're happy to answer any additional questions. If you have any top of mind things that you'd like to ask about, our Q&A feature is also open. So you can send things in and we'll pick a couple of questions to answer at the end of this webinar. We also want to plug our newsletter really quickly. We have copies that we like to send both to people on the outside and on the inside. You can either sign up on our website if you'd like an outside copy, or you can request that a copy of our newsletter be sent to your loved one on the inside via our form, again, on that website, ellabakercenter.org/RJA-info. But yeah, we'll pass it back to Morgan for a nice summary of what we talked about today.
Thanks, Angie. So just in short, all of that information condensed, the Racial Justice Act prohibits discrimination in arrests, conviction, and sentencing, and describes 4 different types of discrimination that violate this law. The RJA allows a hearing to prove a violation and provides legal counsel to assist in that process. It also requires a real remedy. It's not just a court decision or recognition of racism, but a real outcome that will change your loved one's sentence and have a genuine impact. Keep in mind that there are 2 distinct processes, an in-trial process versus a post-conviction process, and be aware of how those differ for your loved one's individual case. EBC has the Racial Justice Act guide available in both English and Spanish that we can send inside to your loved ones for free. And that's available for your access via the link that we posted to our RJA info page. And as Angie already mentioned, you can contact us with any additional questions at policy@ellabakercenter.org.
Thank you, Morgan. And I'll come in with a few final thoughts. The RJA is, like I said, a powerful, groundbreaking new law that's intended to shed light on our criminal legal system and the bias within it. But that light isn't a cure-all. With the RJA, we're calling on a flawed system to recognize and address the harms of its own flaws. So there are limitations. The RJA is new to the courts, and not all attorneys, not all judges are familiar with it, but soon they will be. Don't worry, lawyers are coming. And also, with the disparities claims, we mentioned that statistics comparing your case against others in your county are a big deal, a big part of it, a big part of supporting that claim. Unfortunately, law enforcement is not very transparent with what they do in our communities or any of the data that they have. So that forms a barrier. However, there are also a few opportunities with the RJA that bring me hope. First, California finally has a law that recognizes discrimination in our criminal legal system. It's so affirming to the people that we are, the people who have always been, and the community that we are, and holding each other together. And also, I'm brought to just great inspiration by the powerful advocates and our wonderful assembly member, Ash Kalra, and their commitment to the RJA's successful implementation. Just this year, AB 1118 was introduced by Assemblymember Kalra to streamline the appeals process for a denied RJA claim, and to make bringing an RJA claim with the death penalty a little bit easier. They also secured $8 million in this year's budget, despite the fears of a deficit. These extraordinary organizations and our committed Assemblymember Kalra, they bring me so much hope that the RJA will have a successful implementation, and not only this law, but many other powerful laws like it that are moving through the legislature and will move through the legislature to really speak to the community that we are and the ones that we can be. So with that, I think I'll pass it back to you, Angie.
Awesome. Thanks so much, Maureen and Derek. We have a few questions. Thank you all for sending so many awesome questions to our Q&A feature. Our first question comes from Maceo, who is an Insight Fellow at the policy team at UBC, who asks how someone may obtain data from their county for a disparity claim.
I'll jump in. As I mentioned before, there is a barrier to getting data from your county because of it's largely controlled by law enforcement. However, I think, well, one thing you can do is just ask, and ask them in a written form. Most agencies usually have a media officer in charge of responding to public records requests and requests for public information. But even still, there are groups like the Sentencing Project and PPIC, the Prison Policy Institute, that are just really smart people with data-driven reports that they put out all the time, breaking down how the criminal legal system interacts with our communities. And we rely on them for a lot of policy changes that we've moved.
Thanks for answering that, Derek. Our next question comes from Kat, who's from CopWatch San Diego and also co-founder of San Diego Tenants Union, who asks what the difference is between explicit and implicit bias in the eyes of the law.
Yeah, I can go ahead and cover that. So the RJA allows for claims based off of both explicit and implicit bias. Explicit bias would be A1 claims under the RJA, and implicit would be A2 claims. So explicit bias is more focused on actual evidence of hate or targeting based on race. Some of those examples of that type of language you can see in the Antioch Police Department texting scandal investigation, where they're specifically talking about Black individuals or individuals from other ethnic groups and racial groups, and specifically mentioning their race as a factor and as a causative factor in why they're stopping them, why they're arresting them, those kind of instances. And implicit is also covered by the RJA and often isn't covered under other types of discrimination laws. Those are more coded statements, the types of stereotypes, the comparing a defendant to an animal, and other actions like that, using rap lyrics, things like that to file charges specifically against a person. Derek, did you have anything else to add?
No, I think you covered that great. One helpful rule of thumb for me is that A1 claims, explicit bias, deal with voluntary acts of hate, and A2 claims, the implicit bias, deal with unconscious bias. So things that can don't outwardly express hate or targeting someone because of their race, but gives you that gut feeling that that's exactly what happened. I think that's how I hold them, those two in my head.
Thank you both for answering that. Our last question comes from Ascari, who asks about incarcerated people who have already gone through a full round of post-conviction and have filed habeas petitions before. Are they barred under RJA from filing a new claim?
No. The RJA, within the law itself, it says that bringing an RJA claim isn't seen as excessive. It's not under the same limitations for habeas as most things are. The only rub with that is that, like Morgan mentioned earlier, Prop 36 limited habeas claims for folks on death row. That if you're bringing a habeas claim, when you're on death row, you only get essentially one more time to bring a habeas claim. And if you choose to bring a habeas claim with an RJA claim, that can be the only claim you get. So that's a little bit of something to look out for. But if you are incarcerated for any other crime, you can bring an RJA habeas claim. And if you have a current appeal in the process, your RJA claim can be amended to go in with your current appeal too.
And just to clarify, those potential death penalty and capital conviction limitations are under Prop 66.
Thank you, Morgan. I always confuse that. I'm so sorry.
Thank you guys for answering the questions, and thank you to everyone who came for joining us. If you have any additional questions, or if we didn't get to your question, I'm dropping our policy email again in the chat. But with that, I'll pass it back to Morgan to close us out.
Thank you, Angie and Derek and Samilia and everyone. Thank you all so much for attending and being here. The Racial Justice Act is really important, as you all know, and we're just so excited to share out this information with you and to get our guide out to as many people as possible to help in their continued advocacy. Again, if you have any other questions, please reach out to policy@ellabakercenter.org. I also know that we weren't able to answer everyone's questions that were submitted today, and we will try to get you answers to some of those questions as soon as possible. But again, we are really grateful for you all being here and taking the time out of your days to help learn more about this and spread the word about the Racial Justice Act. And with that, we'll be ending our presentation and let you all get on with your days. Thank you.